Hello, this is Mandy O'Callahan with Keller Williams Realty, and today I'm here to go over the Tallahassee Board of Realtors contract for sale and purchase. And there's a lot of information to cover today, so I hope to answer most of your questions. And since there's a lot of information, I'm just going to jump right in and get to it. So lines 1 and 2 of the contract are where you input the parties' names to the contract. And so here, the first line, we've got the name of the seller. And the second line is where you would input the buyer's name. And you'll want to make sure that you don't use kind of nicknames. You want to use whatever their full legal name is. And so, one way to check what that is, if you're representing the buyer and the buyer's making an offer, is to go to the Leon County Property Appraiser's website and do a search of the address. And then when you get there, you should know the address, of course, so you'll put that in. All right, and then here you will see the names of the sellers, but you want to be careful because sometimes that is not always the most accurate. For example, my last name has got an apostrophe in it, which isn't represented there. So the best thing to do is to go to the warranty deed, and in that you should have the full legal and correct spelling of the names of the parties there. So you would enter that information. Sometimes that information won't turn up on the property appraiser's website. For example, if the seller is a police officer and his records are exempt from public record, then in that case, you'll want to get with the listing agent and have them track down the information you need to be able to properly fill out the contract for sale and purchase. All right, so these two parties or their assignees, sometimes that's a court-ordered personal representative when the homeowner is deceased and the property is in an estate, or someone may have a power of an attorney to sign off on these documents for one of these parties. Agree that the seller shall sell and the buyer shall buy the following property upon the terms and conditions of this contract for sale and purchase. Clause 1, the legal description of the real estate. So here you would input the lot, block, subdivision, unit, and located in which county that you're in. That is not checked when you have this information. And you find that again, if I can find out where we were, right back here. That information is at the top of the page. So here is your subdivision, the unit within the subdivision, and your lot and block number that you would input there. So then sometimes your buyer will be purchasing a house that is maybe rural and not in a platted subdivision, and in that instance, you will want to check that the property is described by Mets and Bounds. So you would still put in the address here, but then in parentheses, you would say the Mets and Bounds description is attached in the warranty, or you have attached a warranty with the Mets and Bounds description, however you want to word that. And what that looks like, let's see if I can find it, is not that one. It looks something like this. So on the warranty deed, there's going to be some directions, and let's see if I can still find it. There's a better example. So these are a description, legal description of the property. So you do not want to try and type this all out on your own piece of paper, because heaven forbid if you make an error and like juxtapose these numbers, then your buyer is going to be buying a different lot of land than was intended in the purchase, and might end up having a title defect and so forth. So it's a good word of advice. Do not write your own Mets and Bounds. Just use the attachment of the warranty deed already attached to that property so you don't have any mistakes. All right, clause 3, closing and possession of the property. So this contract shall be closed, deed delivered, and purchase price paid to seller on or before. And this is where you would input your closing date. Notice it says on or before, so it doesn't necessarily have to happen on that date. It can happen anytime before that. If all the stars align, the lender gets the loan ready and approved before then you might be able to close before them. All right, so when you do choose a closing date, there's some factors that you'll want to consider, such as if your buyer needs a loan, you'll want to work with the lender to see how much time they estimate they will need to close that loan. Usually it's 30, 35 days for a normal conventional loan, but sometimes on VA loans or USDA loans, there's a backlog with the government, or there's more strings attached and more I's and to dot and T's to cross. So sometimes they will take longer. So you want to get that estimate from the lender. Also, if it's a cash purchase, it may be a lot less time. It might be 7 to 10 days if the title company says that they can get that title work done in a short period of time. But another word of advice here, when you go to schedule your closing, the title companies will greatly appreciate it if you don't close on the last Friday of the month. That's when a lot of people try to close, and it doesn't leave time when they're totally booked on those days to be able to address any issues that might come up on that day of closing. And that sometimes those things do come up last minute. So it's better if you can randomly schedule your closing on a Tuesday or a Thursday and not close to the end of the month. All right, possession of the property will be delivered to buyer at closing, at which time seller will have removed all personal items and trash and cleaned the property. Clean the property is sometimes a point of contention. I believe the rule of thumb is that if it is swept clean, surface cleaned, that's sufficient. If you know that your buyers have a different kind of expectation, it might be good to write that in to the contract that they want it professionally cleaned, just so that there's no confusion right up to closing at the walkthrough and any last minute scurrying to get something differently done. At the time of closing, seller will assign all assignable maintenance, repair, and treatment contracts to the buyer, with buyer paying any applicable transfer fees. So listing agents, find out if your sellers have any assignable kind of contracts like AC, air conditioning, maintenance, repair, service plan, if that's transferable, or if they have a termite bond, or if they still have some coverage on their pest control contract and it's transferable. Make sure that that information gets passed on to the buyers. All right, seller will also provide buyers with all keys, access codes, devices, and garage door opener transmitters. Another word of advice, if the sellers do not have the door opener, the garage door openers, or any kind of keys, have them listed on that seller's property disclosure so that the buyer is aware that those things are missing and they're not wondering why they don't have them at closing. Seller shall keep all utilities on and maintain property, including items repaired, remedied, lawn, shrubbery, pool, and other improvements until closing or buyer's possession, whichever occurs first, in the same condition as at the time of the contract, ordinary wear and tear accepted. So it may be enticing for sellers after they get those pretty professional pictures taken and everything looks nice to then let it go after they go under contract. But really, the house, the yard work, all that is supposed to be maintained and kept in the same condition at the time of contract until the day of closing. All right, clause 4. So this whole clause is about financing the purchase of the house. This is all about the loan. Clause 4 is not about, but we will get to it, the closing costs. So I like to tell my buyers that really when they're purchasing a house, there are 2 buckets of money coming from them. And one is all about getting their loan, and one is all about these other kind of costs that come with purchasing a house. So you have the loan and their down payment that they're responsible for paying to get that loan. And then they have other costs associated with purchasing a house, like the appraisal, the survey, they've got the credit check, any taxes that need to be paid in advance, all that, everything in that bucket of money are their closing costs. So this right here is all about the loan. So it is customary in Tallahassee for the initial deposit to be 1 to 2% of the purchase price. That doesn't mean that the buyer has to submit that. They could go under that and it may be acceptable to the seller, but it's just customary that we put in there 1 to 2% of the purchase price. So that's probably what the seller is expecting. So in my example that I'm going to give today, we're going to purchase a $200,000 house. So with a $200,000 house, let's say a $2,500 down payment is in between that 1 to 2%. So that should be acceptable. And that is going to be held in trust in an escrow account by the title company, who's going to be your closing agent. So that is where you would input this information. I'm just using North Florida Title Company as an example, but of course there's many good title companies in Tallahassee. There's Owen Title Company, Smith Thompson Shaw, a lot of people use, Hayward and Grant. Anyway, so you would input the title company's information, its address, the contact name of your closing agent, their phone number, and their email. And make sure you point out to your buyers that this is a good reference tool, the first page of the contract. They can always go back there to see who they need to talk to other than the realtor. If they have any questions about the closing or the title work or something towards the end that's in the settlement statement, this information is right on the first page of the contract. Okay, well, this earnest money deposit, you can signify that, and you would put that same amount here. That amount can either be, oh, you know what? I just put that in the wrong blank, my bad. The earnest money deposit can either accompany, all over the place, can either accompany the contract, or you can say that that earnest money deposit is going to be submitted to the title company within 3 days after the contract. Like, really, you can put any time there, but we are to have that earnest money deposit to our brokerage within 24 hours. Then our brokerage has the remaining time to get that to the escrow company to be able to deposit that money. All right, so we put that there. We're going to give us those 3 days. And then sometimes a contract will maybe call for in negotiations the buyer to submit additional money down. Sometimes if a buyer needs a long period of time to be able to close, sellers don't want to keep their house off the market that long. So sometimes they'll request a certain additional amount after a certain date. Or maybe there's a huge repair that the sale is going to be contingent on, and it's going to take time for that repair. So maybe the seller is going to want additional money at a certain point because of that big contingency that's out there. But it's not too frequently that comes up. All right, so you're going to want to indicate under clause 4C, new third-party financing, and so you're going to want to indicate and let the seller know what kind of loan product your buyer is going to be using to purchase the home, whether it's going to be conventional loan, an FHA loan, a VA loan, Veterans Administration loan, or another loan. And here you can check this box, and if it's USDA, write in USDA, or if it's some other kind of loan product, you would put that there. For purposes of today, we're going to do an FHA loan because it's pretty straightforward. With conventional loans, there's different kind of loan products where they can either put 20% down, sometimes 10, 15, 5% down. With the FHA, we know that the 96.5% of the loan is going to be financed, and that means that the buyer is going to have to bring 3.5% to make a down payment against that loan. So we are going to figure out and do the math as to on a $200,000 house, what that looks like for the amount financed. All right, so the way you do that is you take your $200,000, which is going to be the cost, the purchase price that we're going to put down here at the bottom, and we're going to times that times 96.5%, and we're going to get $193,000, and that is going to be the amount of your loan, amount financed. Okay. Now, we're going to come back to cash, assumption, mortgage, and seller financing, because if you have an FHA loan, none of those apply. But here is the approximate balance of down payment to close. So you have to come up with the remaining amount that is due. Wait, I just put that in. 193. All right, there we go. Now the number's right. 193,000 finance. So there, to get to the $200,000 purchase price, the buyer is going to have to put down the remainder to get up to 200,000. So that's their down payment. So it would be $7,000. However, this amount right here, the earnest money deposit, the amount of initial deposit is applicable to that down payment. So you're going to take that 7,000, that's the remainder due for that, and you're going to subtract the 2,500. So the buyer is going to have $4,500 remaining to pay for the loan at closing. All right, and there's a note about that. This money right here, sometimes we get asked this question from first-time home buyers. They'll say, well, I can write you a check for $2,500, but I don't get paid for another week. Can you just hold on to that and then have them deposit it then? Nope, that money is deposited when that's submitted in that 3 days. That goes to the title company. That title company is going to cash that check and deposit it into an escrow account. So they will need that money on hand because they'll be cashed. All right, so going back here to a cash purchase, an assumption of mortgage and seller financing. Well, if you have a cash purchase, then obviously a loan is not involved. So you would be putting in here aside from the down payment, the remainder amount of cash that needs to be put down to purchase the house. And then assumption of mortgage, what that means is that sometimes when a seller still has a mortgage left on their property, and if that mortgage has a really low interest rate and that type of mortgage they have can be assumed by a buyer, then sometimes it is a really good deal for the buyer to be able to take over the seller's remaining mortgage left on that house. And not all mortgages are eligible to do that, and not all buyers are eligible to assume a mortgage. You've got to apply for it, and we'll get more into depth in that later, but that is what that instance means. So you would put the amount of the mortgage that buyer is assuming. And if interest rates are really high and that assumable mortgage has a really low interest rate, that sometimes can be a very good deal and situation for the buyer to be able to get that lower interest rate by assuming that existing mortgage. All right, seller financing. So this is when the seller actually has enough money to loan the money to the buyer to be able to finance the sale of their own property. We'll also get a little bit more into that later, and there's a special clause addendum that you need to fill out if you go that route. So I will get into that later, but that is that situation. Clause 5, expenses. So this is important to read at the beginning. The seller has agreed to pay any of buyer, if the seller has agreed to pay any of buyer's costs, the buyer agrees to pay in advance the cost and be reimbursed by seller at the time of closing. Should contract not close, each party will pay for items stipulated below, except the seller will not be responsible for any costs on behalf of the buyer. So it makes sense that if the seller is going to pay costs towards the buyer's closing, if it does not close, then the seller does not owe any money for that buyer because there's no sale, there's no closing costs. All right, so these are all itemized things that the buyer will typically pay for because they usually pertain to the buyer getting a mortgage. So you'll see here that you would check this for any loan costs in excess of seller's contribution, but you only check that if you're going to negotiate the seller contributing towards the buyer's closing costs there. You check any closing costs required by the lender. The appraisal fee, if you have a loan, that lender is going to require the property be appraised to make sure that that's a good investment for the bank, that they're loaning you the amount of money that equates to the value of the house. And the buyer's attorney's fees. So that doesn't necessarily mean the buyer has to hire an attorney. It's just that if the buyer does hire an attorney, they are responsible for their attorney's fees. The bank's going to require a credit report, so you'll check that. Doc stamps on the note. You're going to see in both of these some requirements for taxes. That's basically what those are. And it's a really good idea to go to the Florida Department of Revenue's website, and you can learn a little bit more in detail about what that means. So in Florida, whenever someone has a promissory note, which is a written obligation to pay money, that's what a mortgage is, then they're going to be subject to this tax. And here's the tax rate. So 35 cents per $100. So basically, you would divide the total purchase price, in our case, the $200,000 by $100. And when you get that number, you times that times 0.35 to get your amount that's due for that. All right. So that's the doc stamps on the note. And then your lender is going to require a flood certification letter to determine from a third party if the house is in a flood zone and whether it will require flood insurance. HOA enhancement fees. Sometimes your buyers will be buying a house that's in a subdivision that has an HOA that has a lot of activities. I like to use the example of Southwood in Tallahassee because they have a huge fireworks display and they've got like a Christmas event, a Halloween event. And so when buyers purchase in this neighborhood, they're charged a 0.1% of the purchase price. And so it usually equates to a few $100s that goes towards those kind of activities for the neighborhood. All right. The next thing is a home warranty. You'll just want to make sure and explain and differentiate a home warranty from home insurance for your buyers, especially first-time home buyers. They get confused by that. So there's several providers for home warranties. The most well-known ones are American Home Shield, Old Republic, First American Home Warranty. And they can go on their websites and see what kind of coverage that provides, but usually it covers electrical, plumbing, some appliances, not all of them. They usually don't cover unless you upgrade it, a washer and dryer. But usually you can get these home warranties under $600, some of them under $500. And what that means is it's a year of coverage at that price usually, and the homeowner will have to pay that $500 for the warranty, and then there's a one-time call-out fee depending on the company. Some charge $75, some charge $100, $125 to have someone come out and do the repair, but it's just the call-out fee, and then everything else is covered. Sometimes if there's a house with older air conditioning, older hot water heater, it makes sense to get that. So you'll just have to work that out with your buyer. So intangible tax on the mortgage, this is a requirement in statute. I'm going to catch up on my notes so I can find the statute. Let's see, section 199.133. So this is a one-time levy of non-recurring tax. And that is that intangible tax on a mortgage. In here it says it's non-recurring tax of $2 million. So how you calculate that really is it's 0.2% of the purchase price. So you take the purchase price of the property in our example of $200,000 and times that times 0.2%, and then you would get that number. Loan discount points. Right now with our low percentage rates, you don't see this very often, but buyers can buy down their points, and then that will impact the amount of their monthly payment. Loan origination fee, this is the amount that is charged by banks to process and really do the legwork on the loan. Sometimes they bring in other types of fees under that title as well, but Mortgagees title insurance, just make sure that you explain to your buyer that that kind of title insurance is not to the benefit of the homeowner, that actually protects the lender and the lender's ability to make any claims. Owner's title insurance does protect the homeowner, the purchaser of the property, so that protects if any title defects do come up, then that homeowner is insured against those claims. All right. Prepaid interest, taxes, hazard insurance, and homeowners dues. A lot of these items are prorated things, and we're going to get more in depth and explain those kind of costs later. Prepaid mortgage insurance. So on some loan packages, say you have a conventional loan and you're paying 20% down, you don't have to pay this prepaid mortgage insurance. But if you have to get a conventional loan where you pay less down, then the banks want to see that you have the ability to consistently pay toward your mortgage. And if you do, and you have a certain amount of equity, I believe it's 20% toward your mortgage, then you can request to have this prepaid mortgage insurance, which is an added charge to your monthly mortgage payment, removed after you get enough equity. And that can significantly kind of make an impact on your monthly budget. So that's good to explain that to your buyers and make sure that they know to request to take that off later. All right, recording fees, that's to record the documents, county, and then you've got your survey, which plots out the lines of the property to make sure that there's no encroachments and title defects on the property, and outlines where any easements are. And then here is where you would put any other fees that would be applicable and the buyer would be responsible for paying. I've been seeing a lot of agents putting inspection fees in here. That is, you don't have to do that. It is redundant in, I think it's lines 170, 171. It already outlines in the contract that buyer shall be responsible for the cost of all inspections, but it doesn't hurt if you want to put it there again. All right, so now these are the seller's costs, and these sellers kind of outline the seller's responsibilities, which makes sense because these are things pertaining mostly to paying off a mortgage or paying the commission to the realtors for selling the property. So this first section we talked a little bit about, this is where you would check if any costs are negotiated from the seller to pay to the buyer at closing. And sometimes there's some confusion between sellers and buyers as to whether this is paid up front. It's not. So if the seller has any equity in their property at closing, like they're going to make $30,000 off the sale, and say they negotiated $3,000 to be paid to the $3,000 towards the buyer's closing costs, then instead of the homeowner getting the full $30,000 back at closing, they would only get $27,000, and the $3,000 from the net proceeds would go towards the buyer's closing costs. All right, in this case, we have an FHA loan that we're pretending to work on. And so we would want those costs first to go towards any FHA costs that are required of the seller. And then some prepaid items, we're going to describe those more in depth later. Any discount points if they wanted to buy down the loan. And then any other costs, including those buyers has agreed to pay for in clause 5, you always want to check that because you definitely want to at least cover any of these outstanding charges that the buyer is going to have to pay at closing. All right, so then the seller is typically responsible for the brokerage fee. However, sometimes there's a for sale by owner instance where the for sale by owner is not willing to pay the buyer's agent commission. And if that's the case, you would uncheck that. And the buyer, if the buyer is willing to pay that commission, then you would check that and make that one of the buyer's costs, the brokerage fee for the buyer's agent. Typically though, it's the seller's cost. Okay, the doc stamp on the deed, again, that's where the sellers pay this, and this the Department of Revenue's website has got, again, good information about that. So whenever there's a document that transfers an interest in Florida real property, and that's what that doc stamp on the deed is, then the tax rate is 70 cents on each $100. So you would do very similarly to the doc stamp on the note. You would divide the $200,000 by $100, and whatever that amount comes out to, then you would multiply that times 0.70. That's 70 cents of 0.70, and then you would get the amount of that doc stamp that's on the deed. HOA estoppel fees. So whenever a title company goes to the HOA to determine if there's any outstanding HOA fees, assessments, anything that the seller has not paid, and that's why it makes sense that it's here, because they're checking to see if the seller is up to date on those kind of payments. The HOA can charge an estoppel fee, and that's actually authorized per statute. That is, I'm going to take you there. $720 and 0.3085. So this governs the HOA association's ability to be able to, hold on, 30851, I thought that was the wrong one. I'm going to go back. Here we go. Here's the estoppel certificate. So this is the legal authorization for those HOAs to be able to charge money for those estoppel certificates. And this is the information that is supposed to be contained in those estoppel certificates. So basically the title company will ask for that estoppel certificate, and the HOA will charge a fee to be able to do that, and then fill out this information and send it back to the title company. All right, and then sometimes the HOA will separately charge an HOA transfer fee, and usually that's for the HOA putting together a package to give to the new homeowner that includes the HOA, the subdivision's handbook of rules and regulations and schedule of events, things like that. So you would input that there. Again, you can negotiate with the seller if the buyer doesn't want to buy a home warranty, and it's not necessary, but you could get the seller to maybe cover that if there's some aging things in the house and put the amount. You may only put $250, knowing that the buyer is on the hook to pay the remainder for the home warranty, for example. And then if the seller has an existing mortgage that needs to be paid off, then you'd want to check mortgage satisfaction recording fees. And then here it's customary for the buyer to pay these, the mortgagee's title insurance and the owner's title insurance, because it pertains to purchasing the property and getting that title insurance. However, sometimes the seller really wants to choose who is going to be performing the title work. And if the seller is willing to pay for that title insurance, which is a pretty hefty price, then they can actually elect to do that and choose the mortgage and owner title insurance if they're willing to pay for that. All right, seller's attorney's fees if the seller gets an attorney involved, and sometimes the buyer will ask the seller to pay for the survey, or sometimes the seller has a survey from not long ago that they can just pass on to the buyer, which will save the buyer some money. However, be careful with that, because when the seller provides their survey to the buyer, if there's been any improvements to the property, like a new fence built or a new attached garage put on the property, then that is a change that the seller cannot sign an affidavit to say that there's been no changes to the land, so that survey may no longer be good. Another thing also, even though it saves your buyer some money, you'll want to warn them that if they don't get their own survey and there's a problem with the old survey, they won't have any legal standing to sue that surveyor, because they were not a part of that original contract between the seller who previously hired that surveyor. So they have no legal standing if that survey is wrong. It's called parity of contract, PARITY of contract. All right, and then here is where you'd put any other fees that the seller is willing to pay. All right, these are the following to be ordered by. This is different from who's paying. Just because they're paying for it doesn't necessarily mean it needs to be ordered by them, but typically that is the case. So you would put the closing agent, in our example, is North Florida Title Company. Survey, you can choose who you want here for survey, AD Plat, Meridian Surveying. Anyway, so, or if you don't know, you can just put to be determined, because maybe you need to track down who did the survey last to get a discount on getting that survey recertified, or maybe they'll just give a discount because they've performed that survey before. Home warranty from whatever company that you want to go with, Old Republic, First American, American Home Shield, or again, if you want time to shop around, you can just put to be determined. But at least you've signified it's to be ordered by which party. All right, clause 6, personal property included in the purchase price. So this is a section that you want to be very, very careful about what is selected. And when you're going around the house and you have a feeling that your customers may be putting an offer on it, that's where you want to start taking notes about things you wouldn't normally think of being in or around the house that might, there might be a decision made as to whether it's going to convey with the property or not. A lot of times there's some miscommunication about the washer and dryer, and so you want to make sure on the listing side whether your seller wants to keep those or take those, and you want to make sure with the buyer whether they want those conveyed or not, and make sure if they do that those are checked to convey. And then sometimes if it is a house that has like a carriage house or a separate building that's rented out, that you remember to include those things, those other, refrigerators, ovens, washer, dryer, dishwasher. Make sure that you list all those things attached with the other house. And then there's other things that you want to keep in mind, like if there's a playground or play set out back and the buyer wants to include that in the sale, just make sure that you're dotting your I's and crossing your T's. And you'll also want to reference the seller's property disclosure, because oftentimes the homeowners or sellers will specify stuff that they want excluded from the purchase. So you'll want to keep that in mind when you're negotiating and make sure that's sorted out right from the start. All right. Catch up on my notes real quick. All right, so clause 7 is the financing clause. And if your buyer is going to be using or getting a loan to be able to finance the purchase of the property, you would check this, because then these terms are going to apply. So buyer shall have 15 days from the contract date to secure to buyer satisfaction new third-party financing as stipulated in clause 4C, excuse me, plus any applicable FHA, MIP, VA, or other funding fees. I'm going to pause right here because then I want to explain how the timelines are calculated throughout this contract. So 15 days from the contract date. So contract date in this contract is a defined term. That means the date that all parties signed off on the last document that is the contract document. It can either be this initial offer that is submitted and all parties sign off and the sellers accept this, or it can include a counter offer that is made timely and all parties sign off, or it could be, there could be a counter offer and another counter offer and another counter offer. That last counter offer that is fully executed by all parties, whatever date that is last signed off on is the contract date. However, that for purposes of counting time, that is not day one. Day one is the date after the contract date. So the contract date is considered day 0. The day after the contract date is considered day 1. And when we calculate that time, it is not from the moment that the contract was signed and starting that moment the next day. These are full calendar days. There's a clause at the very end of the contract. Go ahead and scroll down there. And it tells us that time is calculated. All references to time frames shall be calendar days, including weekends and holidays, and in the time zone where the property is located. So when those 15 days are calculated, they're whole days. So on the 15th day, it does not expire until midnight. because you calculate that whole day. There's a lot of confusion sometimes about the timings of contracts. So hopefully that helps. All right. So here we just found out that the buyer has 15 days to be able to buyer's satisfaction, obtain new third-party financing. So this is very significant because sometimes lenders can become creative in all kinds of ways to be able to make it happen and get that loan to go through, but it may not be satisfactory to the buyer if the buyer is on the hook to pay an outrageous annual percentage rate or lending fees, and that's not satisfactory to the buyer. So just keep that in mind. They have 15 days to the buyer's satisfaction to obtain that financing, and make sure your buyers are communicating in that time period with their lender so that if there's any red flags or anything coming up and it looks like they're not going to be able to get finance, that they're able to pull out of the contract in time. Once that 15-day period passes, if buyer has not notified the seller of the buyer's desire to void the contract due to financing, then the contract's no longer contingent on financing. That means they lose their earnest money deposit if they pull out after that point. That does say, with the exception that any provision in clause 8 pertaining to the appraisal shall be applicable. And we're going to go into that. If there's a low value appraisal that comes out or repairs that are flagged, the buyer has another opportunity aside from the 15 days to be able to walk away and get their earnest money back. But for purposes of financing, after that 15 days, if the buyer doesn't let the seller know it's not going to happen, then they waive that right to be able to get their earnest money back for financing reasons. So, and this just says at any time within that 15 days, the buyer may void the contract in writing using the TBR termination form, and then the buyer is entitled to the refund of their deposit. But again, once the 15-day period passes, if the buyer's loan is declined, then the deposit will not be refunded for any financing reasons. So buyer will make loan application no later than, and there's blank. And if you want to keep the 5 days, that's fine, but you still will want to fill in a number there, and that prevents anyone from fraudulently putting in a different number later and claiming that they had more time. So go ahead and just put in the number. And then failure to make complete loan application within 5 days from the contract date, including providing all requested documentation and disclosures, completing the intent to proceed, and paying for and instructing, that's the buyer telling the lender to order the appraisal. It doesn't mean the lender has to order it in that time. That's just the buyer has to instruct within 5 days to the lender to order the appraisal. Otherwise, it constitutes a waiver of the financing clause. So make sure that your buyers are making their complete loan application within the days that you've provided there, so that they are not waiving their ability to walk away in that 15 days and get their money back. All right, buyer and seller authorize lender and closing agent to disclose information regarding the status and conditions of the loan application and approval, and provide the closing disclosures to the buyer, seller, realtors, and the closing agent. So it's important, listing agents, for you to realize that not only can information be disclosed to the buyer's agent, but the listing agent can call the loan officer and find out the status of the loan and any conditions of the loan. They're not going to find out from the lender what the buyer's credit score is, or how much money they have in a bank, or how much money they make with their jobs, but they can at least, keep up on the status of the loan with the lender. They're obligated to do that. Okay, cash. So if you have a cash purchase, if the buyer has enough cash to submit a cash offer, they will need to provide proof of funds to that seller that they're able to purchase the property with cash. And they can either have something at the ready and it can accompany the offer, but sometimes an offer is made on the weekend and that buyer can't get with their bank to have a statement to show that they can pay cash for the purchase. So in that instance, then you would want to give the buyer a couple of days to be able to provide this proof of funds. And typically, so that listing agents can prepare their sellers, buyers usually only get a letter from a bank that says not exactly how much money they have in the bank. It will instead say, Mr. Smith has sufficient funds to pay $200,000 from his whichever kind of account. Sometimes sellers I mean, sometimes buyers on their own they can print out their bank statement, redact things, show their balance, or sometimes they'll send over an investment account to show that they've got enough money to be able to cash out in an investment account and pay for it. So anyway, those are kind of some things that you can expect there. And clause C, assuming the mortgage, this is where I talked about getting more in depth. So again, when a seller has got an assumable mortgage, and especially if it has a low interest rate, that might be enticing for a buyer to be able to qualify to be able to get that mortgage. So most likely that buyer is going to need to qualify, fill out an application with the seller's lender to be able to take over. And of course, these things need to be disclosed to the buyer, the adjustable interest rate or the fixed interest rate, and what the interest rate is going to be at, and how much in monthly principal and interest that is going to be. And if there's any kind of insurance premium on that, any other fees that's associated with taking over the mortgage, that needs to be disclosed. So here, this contract is or is not contingent upon release of liability of seller from all mortgages assumed. The seller is most likely going to want to be released a liability on the mortgage that's assumed by the buyer in case the buyer defaults on that mortgage. Seller shall furnish a status letter from each mortgagee setting forth the principal balance, escrow balance, method of payment, and standing of each mortgage within 5 days from the contract date. The buyer wants to make sure that that seller isn't in default, or they're not misrepresenting actually what the interest rate is. All that information needs to be handed over to the buyer. Buyer shall make application for assumption if required by seller and lender within 10 days from the date of the contract. Buyer will pay any mortgage charge for change in ownership and purchase escrow account. If buyer is denied credit commitment, buyer must notify seller within 2 days of denial of intent to void the contract and provide lender documentation of credit commitment denial. So the buyer has to prove that they're walking away because they have not been able to get approved for assuming that mortgage. Notification will be made on the TBR termination form, and buyer is entitled in that case to receive the refund of their deposit. Clause D, seller financing. And just remember that if you're going to check this, if the seller is going to finance the purchase of the property, then there's also a special clause addendum. I'll go over towards the end, and you'll want to fill that out. Also, if you're doing either one of these, an assumption of mortgage or seller financing purchase, you're probably, if you're a new agent, you're going to want to get with a more experienced agent to kind of handhold and help you get through those things. Make sure that you're doing it right. All right, seller financing. So purchase money note and mortgage from buyer to seller bearing interest rate at. So again, similarly, you're going to want to provide what the interest rate is for that loan and for how many years and how much the monthly payment is, or if you want to do it on a quarterly basis. Basically, you want to spell out the terms of the loan. And aside from spelling it out here, this is where it talks about completing additional paperwork. And these kind of loans are regulated federally. So there's a lot to look into when a seller is going to finance. I would suggest definitely getting with an attorney, maybe even a CPA, and make sure that all that paperwork is completed correctly. Further terms of purchase, money, mortgage, and note to seller shall be agreed upon by buyer and seller within 15 days of the contract date and shall contain customary terms contained in such documents. If not agreed upon within the 15 days of contract, so if they can't come to an agreement on all the terms of the seller finance loan, then the contract's terminated and buyer is entitled to their refund of their deposit. All right, and then again, buyer and seller advise to seek legal counsel. Definitely a good idea if you're going to draft up that kind of loan. Okay, clause 8, appraisal. Buyer is advised to have an appraisal on all transactions. So for a conventional loan, these are the terms of what happens for an appraisal if it comes in low or some repairs are flagged. So if you have a conventional loan, you check that. And it says if appraisal sets forth the appraised value of less than the purchase price, like on our $200,000 house, if the appraisal said, no, it actually was only worth $180,000, or if it requires repairs in conflict with or not addressed in the contract, like the appraiser flags a bunch of WDO repairs or a roof leak, buyer must notify seller and provide a full copy of the appraisal report within 2 days of buyer's receipt thereof. So the buyer only has 2 days to provide that appraisal that has lesser value or flagged repairs to the seller. And seller will have, and seller will have the option of either selling the property in accordance with the appraisal terms. So the seller can say, all right, I'll reduce the price down to 180,000, or the seller can say, I'll repair that roof leak. And then we can get the appraiser back out here, show that it's been repaired, and then we can go forward to close. If the seller decline, however, the other choice is the seller can decline to do anything. If the seller does that, and the sellers must notify the buyer in writing within 3 days of that seller receiving that appraisal. Within 2 days of receipt of notice from the seller that the seller will not sell the property in accordance with the appraisal amount and terms, buyer will have the option of, so if the seller's not going to do anything, then that buyer's got to decide within 3 days of that notice from the seller one of these things. The buyer can either proceed with closing on the contract without the regard to the amount of value of that the appraisal came out to be, or the terms, like any repairs that are needed. So if that's the case, then the buyer has got to cough up that difference in what the appraised value is and what the actual purchase price is of the property. In our case, the buyer would have to come up with $20,000. Or the buyer can say, that's fine, they're small WDO repairs, I'll get them repaired, we'll have the appraiser back out, buyer will pay for it, and then you can continue to close. Or the buyer has the option of going ahead and terminating the contract and using the TBR termination form to be able to receive that refund of the deposit. I'm going to real quickly show you what the termination form looks like. So this is the termination form, and of course you put the parties there, the buyer, seller, the address of the property, the date of the original contract. And then you would put, if the buyer is walking away, for example, for that appraisal, then you would put the buyer hereby notifies seller that check here that the appraisal came in under value. Or in clause 11, which we're getting to, there it was an unsatisfactory property inspection, or like in the clause that we talked about in the financing clause, if they're unable in that 15 days to obtain satisfactory financing. Just be careful when you check this and put something other in there, that it's not something that there's not a valid reason in the contract to get the earnest money back. If you just put, buyer doesn't like the house anymore, that's a breach of contract. There's nothing that says that the buyer can get their money back if it's not based on an inspection or the inability to get financing or the appraisal. Just be careful about what you write in the other box. And then, of course, by signing this termination, buyer and seller release each other and sales associate and brokers from any claim. Seller acknowledges receipt of copies. So here's the thing with the termination form. The way the TBR contract reads is that when the buyer signs this form and hands it over and delivers it to the other agent, it's automatically terminated. It's called a unilateral termination. However, just because it's terminated doesn't mean that the title company is going to release the deposit back to the buyer and pull that money out of the escrow account. They are going to still want the seller's signatures. So even though it means that the buyer, if they just sign off on there, is no longer bound to the contract, if it meets one of these contractual ways to get out of the contract and get the earnest money deposit back, they are likely not going to be able to get their earnest money deposit back until the seller signs off and this is provided to the title company. Okay. So then under 8A2, if the appraisal is insufficient to meet the terms of the loan approval other than value or repairs, like it's perfectly valuable as to what the contract says and there's no repairs flagged by the appraiser, but then I'll give you some examples. And then within 2 days of buyer receiving notification of that insufficiency in the appraisal, buyer may void the contract by notifying seller and writing on the TBR termination form, and they're entitled to the refund. So sometimes an appraisal will flag something that doesn't have to do with the repairs or value. For example, if there is a house that is in an agricultural area zoned for agriculture, and there's certain loan products that that a lender cannot provide in an agricultural area, then the appraiser may say that it's a no-go. Or sometimes appraisers will flag that there's been an improvement on the property that has not had a permit pulled and closed on it, and the lender may say, then we can't provide a loan because there's no permit on that improved property. So anyway, in those cases, it's really not a negotiable item, at least with the agricultural zoning, and so that's when the buyer is eligible to just go ahead and void the contract and get their earnest money back. All right, so this is important. So for FHA, VA, or other government insured or guaranteed financing, like a USDA loan, the provisions of Clause 8A shall apply with regards to repairs. So that doesn't say value there because we address these down here, but with regard to repairs required by the appraisal. So if you have an FHA, VA loan and the appraiser flags repairs that are required, then this kicks in. Then the buyer has got to notify the seller of that in the appraisal. And the seller can either make those repairs or do nothing, and the buyer has the option to either proceed and do the repairs themselves or terminate the contract. All right. So here for the FHA regarding the appraisal, in our case, we would check that. And then it says, it is expressly agreed that notwithstanding any other provisions of the contract, the buyer shall not be obligated to complete the purchase of the property described herein or to incur any penalty by forfeiture of their earnest money or otherwise, unless buyer has been given in accordance with HUD, FHA, or VA requirements, a written statement, move on, setting forth the appraised value of the property not less than the purchase price. So the buyer is not obligated to go through with the loan unless the appraiser comes out less than the purchase price. So if the value of the property is the purchase price or over, then the buyer is obligated to go through the purchase. However, if it is less than the purchase price appraised at that value, the buyer shall have the privilege and option of still proceeding. Again, they would just have to pay the difference of the value. All right. And then this just says HUD does not warrant the value nor the condition of the property, and the buyer should first satisfy himself that the amount they are paying for the condition of the property is acceptable, the pricing condition. This VA appraisal clause is very similar, and it says it is expressly agreed that notwithstanding other provisions of the contract, the buyer shall not incur any penalty by forfeiture of earnest money or otherwise be obligated to complete the purchase of the property described herein if the contract to purchase price or cost exceeds the reasonable value of the property established by the Veterans Administration. The buyer shall, however, have the privilege and option of proceeding with the consummation of the contract. All right, so this is again for a cash purchase, seller financing, or other new third-party financing, which might be like a rich aunt that can finance the property for the buyer. So because these do not pertain to getting a government-backed or issued loan, then since it's not with a lender, then they do not have to get an appraisal. But if they want to find out from a neutral third party what the appraised value is, they may order an appraisal in those circumstances. And if they do elect to do that, then here they have the same protections. They may have the same protections up in 8A. Here it says buyer may select and order an appraisal by a state licensed or state certified appraiser within 5 days of the contract date. So that's the stipulation. In order to get those protections, if they decide to do it, they need to do it within those 5 days. And then if they do, the terms of that clause 8A, where the buyer and seller can go back and forth and decide how to handle the appraised value, that applies. Buyer shall be deemed to have waived buyer's right under this clause to get that appraisal and go back and forth if buyer fails to order an appraisal. So in those circumstances, they gotta order that appraisal fairly quickly. Clause 9, hazard insurance, flood hazard area. So within 15 days of the contract date, A, buyer may determine that a hazard and flood insurance, if applicable, are available to buyer satisfaction. You're going to want to, if you determine at all that a house may be in a flood zone, and a couple of ways to do that. One easy way to kind of initially look is when you pull up the house on the property appraiser's website, you can pull up the property info sheet. And when that comes up, you can scroll down to the very bottom. And here in the special flood hazard area designation, there may be a letter like A or Z or whatnot. But anyway, if it signifies any kind of letter there, it means that it's in a flood designated flood zone. And from there, you can go to the FEMA website and get more information about the flood zone that it's in and exactly where around the house that is. And if you determine that, then your buyers need to immediately contact whoever they determine they're going to use for their home insurance, homeowners insurance, and find out if they're going to be subject to flood insurance, which can be kind of hefty. So if they get quoted flood insurance for like $1,500 annually, that might be too much for them to swing to pay that each month, and might need to walk away from the contract. And they have that 15 days to do that for that reason and get their earnest money back. So that's A. B, buyer may obtain a flood certification letter to determine if the property is in a special flood hazard area. The bank is going to order that letter, and you'll see that cost passed on to the buyer in their loan estimate summary and settlement statement. At any time within the 15 days of contract date, buyer may void the contract by notifying the seller in writing that they are voiding the contract because of either of these reasons, and notifications to be made on that TBR termination form that I pointed out to you, and the buyer is entitled to the refund. Clause 10, survey. Buyer is advised to have a survey on all transactions. If a survey shows an encroachment, it will be treated as a title defect pursuant to clause 12, and we're going to go over that a little more in clause 12. 11, clause 11. So I tell my buyers that really this is one of the most important clauses in the contract, and to pay particular attention to this one. This is also known as a due diligence clause, because the buyer has got to use their due diligence to use that 15 days to inspect the property and determine if they want to go forward with the sale. So reading this, the seller represents that any known facts concerning the condition of the property have been disclosed to the buyer and realtors. And there is another clause in here in this contract about required seller's disclosures. So I'll go a little bit more in depth with that in a little bit. Within 15 days of the contract day, buyer may have the property inspected by state or county licensed persons dealing in repair, construction, or inspection, including but not limited to radon testing, home inspection, or wood destroying organism inspections, to determine if there are defects. Wood rot is very, very common. You may even want to prepare your customers that it is likely that wood rot is going to be found. And some loans require a clear WDO, which means for some loan products, and you'll want your buyer to check with their lender right away to see if they're going to need a clear WDO to be able to get their loan. I'm sorry. And if they need a clear WDO, then if, for example, we're going to get down to this below, and it's an as-is contract, then your buyers need to be prepared maybe to be able to make those repairs and have the WDO inspector come out, show that everything's been taken care of. There's no existing termite damage. There's no more wood rot. So just keep that in mind when you're looking at houses with your buyers. And if there's a lot of wood rot, those are potential costs maybe if your buyer needs a clear WDO for your buyers. All right, for WDO inspections, a defect is infestation and or damage by termites, any wood destroying insects. So it might be termite, might be powder post beetles, or wood destroying organisms, including but not limited to wood rot, there you go, affecting any improvement on the premises unless specifically excluded. If a WDO inspection is done, buyer acknowledges that fences are excluded from the WDO. So fences in Florida are automatically excluded because we're so lucky to have hot and humid and moist environments that rot fences and decks really fast. So you don't want the sale of your house falling through because you have a rotted deck, rotted fence. That also may pretend to also apply to decks. Also excluded from the WDO, so you can talk with your buyer and see if it's a good idea to exclude decks, sheds, others. So if there's a small wooden deck, you don't necessarily want the sale to fall through because the deck is completely rotted out. Especially if it's cheap, easy deck or part of the deck that can be replaced by the buyer later on. You can exclude a shed. Again, that's separate and apart from the house, so you don't necessarily want the wholesale of the house to fall through based on some wood rot found in a shed. And of course, you can mark maybe something else that you want excluded from that WDO inspection, like a big wooden pergola. But anyway, that's a judgment call that you need to make between you and your buyer. At any time within the 15 days, buyer may terminate contract by notifying seller in writing that inspections are not satisfactory to buyer. Again, satisfactory to buyer. So the seller might think that that's a terrible reason to walk away from the sale if they don't like the doorknobs don't lock really well, and that's discovered at the inspection, but it's got to be satisfactory to the buyer. Notification will be made on the TBR termination form, and buyer is entitled to receive their refund. So that 15 days, again, counting from day one after the contract date, that 15 days, it's very important to keep in mind so that the buyer can elect to walk away and get their earnest money back. Seller agrees to provide access in all utilities for buyer's inspections and to keep all utilities on until the day of closing, not just post inspections when the seller knows they're done with inspections, until the day of closing. It's important to have this on for the walkthrough as well. Or buyer's possession, whichever occurs first. Buyer shall be responsible for the cost of all inspections. So the seller may have not used ever their gas fireplace and never connected the gas, but the way the TBR contract reads, the seller needs to have all utilities on for the buyer to be able to make those inspections. So that seller should connect that gas. If buyer fails to make inspections or deliver written notice within 15 days of the contract date as stipulated above, buyer waives the right to do so and agrees to accept the property in its current condition, except that seller is required to maintain property in the same condition at the time of the contract. That's that maintenance clause that we read way early up in the contract. Seller will provide buyer with copies of paid invoices for all repairs made to the property by third-party persons within 90 days prior to the closing date. So if the seller's had any recent repairs, they need to hold on, and listing agents, you need to tell them to hold on to those invoices so that they can be provided to the buyer. Any repairs required, and by the way, that's repairs made by third-party persons. If a homeowner makes their own small repair, puts in their own new light fixture or something like that, it's not included. This is repairs made by third-party persons. Any repairs required under this agreement shall be completed pursuant to Chapter 489 Florida statutes and will be done in a lawful and workmanlike manner. Just so you know, they are supposed to be using these licensed repairmen under 489 Florida statutes. I'm going to go there just so you can see. That's important because, hold on. All right, that's important because this governs these contractors, electrical and alarm system contractors, and even septic tank contractors. And when you look at these laws, these contractors are governed by, they have prohibited acts, they have penalties for prohibited acts. So our contract kind of hooks in these laws. So just make sure that those sellers are using these licensed people to do those kinds of repairs. All right. Buyer will provide seller with complete copies of all inspection reports within 15 days of contract date if contract is terminated for any reason. Again, all inspection reports. So even if the buyer is just walking away because of something found in the home inspection, they still, when they fill out that termination form and they send it over to the seller, it needs to be accompanied by all the inspection reports, the radon inspection report, the home inspection, irrigation inspection, WDO inspection, all inspection reports. And that's if it's terminated for any reason. So here's 3 options that your buyer has under the inspection clause. So the buyer can either accept the property in its present as is condition, not requiring the seller to pay for any repairs. However, that's subject to the inspection provisions in here of clause 11, which means they still get their 15 days to inspect the property, and within that 15 days can still walk away and get their earnest money back. So they can either do that, and the buyers need to understand that if they are making an offer and want that offer to be a really good offer to the seller, and therefore are offering it as is at the price that they're offering to purchase the house, that this means that they cannot require the seller to make any repairs. They're buying it as is. However, another option for the buyer is that the buyer can have the seller set aside a certain amount of money for any repairs that come up in the inspection that are needed, and the buyer needs to request those repairs within 15 days of the contract date. And then the rest of this is in a form I'm going to show you. This specific request for the repairs that the buyer is asking for in that amount is to be made on this TBR request for repairs form. And let's see if I can. All right, so this is that form. So the buyer has that 15 days if there's money set aside to ask for repairs. So here you'd put the buyer, the seller information. When you make that request for repairs, you still need to attach all the inspection reports so the buyer can see the pictures of what repairs are needed and so forth. And again, those repairs need to be completed pursuant to 489 Florida statutes, which governs those licensed contractors. And they need to be done in a lawful and workmanlike manner, so they can't be, done unprofessionally. And then the seller is responsible for arranging those repairs. The buyer needs to list out in here the priority of the repairs that need to be done. And if the buyer finds out that they need a clear WDO for their loan to go through, then those should be listed first. Those WDO repairs should be listed first. And then typically it's a good idea to maybe put anything that was flagged as a hazard and safety issue in the home inspection on here. You want the house to be safe for your buyers when they move in. And then of course, anything maybe cosmetic or aesthetic that could be improved and repaired below that. So make sure that you prioritize those repairs. Now, and then the buyer would sign here, the seller would initial here, and then this page, this request for repairs, is the seller's response. So this page has got some important timelines that need to be paid attention to in here. So once the seller receives from the buyer this list of requested repairs, this is very important for the seller and for your listing agents to explain to your seller that the response from the seller to buyer is required within 5 days of the receipt of this request. That seller has got to respond to the buyer as to what they're going to do repair-wise within that 5 days, because this is big and this is why it's highlighted. If seller fails to respond to this request within 5 days, then the seller will be deemed to have agreed to make the requested repairs and remedies without regard to the amount stipulated in Clause B of the contract. So the buyer has then all the incentive in the world to list every repair that they can think of, because if that seller does not respond in 5 days, they're on the hook to make all those repairs. So sellers need to pay attention and be ready to respond to those requested repairs within that 5 days, so they're not on the hook for all those repairs. All right, so here the seller can respond by either agreeing to make all the repairs. Maybe there's only a few repairs listed anyway. They can agree to make all the repairs, and if they do that, then no other further action is needed by the buyer to sign off on anything. But if the seller checks here and they stipulate to certain repairs that they're only willing to cover there, Then the buyer can agree to accept the balance of the repairs. That's where you get more into this. So the seller puts their response under 2, they sign here. And then if the seller has checked 2 above, then the buyer has got to indicate within 2 days if the buyer is okay with the seller only making those repairs. If the buyer does nothing, then the buyer automatically is deemed to agree with what the seller has agreed to pay for and repairs to be completed. So the buyer can also check here, buyer agrees with seller's response. Again, if the buyer does nothing and 2 days lapse, then they've been deemed to agree with it. Or the buyer has the option of terminating the contract. So the buyer can go ahead and terminate the contract and then is entitled to their full refund and deposit. And there you've got the buyer's signature box. So that is the options if money is set aside there. And then this just reiterates that the seller's failure to respond within that 5 days is just deemed accepting to do all the listed repairs by the buyer. All right, and then again, if the buyer needs clear WDO, they need to make sure that those things are prioritized and repaired. All right, if any repairs are requested by the buyer will provide seller with complete copies of all inspection reports along with a request for repairs. And we went over that on the request for repair form. All right, option C. So option C, you never really want to check unless you have an investor who is buying a property and doesn't care what kind of condition the house is and plans to demolish the property anyway. Anyway, basically this is the buyer checking that they acknowledge that the buyer has inspected the property prior to the signing of the contract. Maybe they've seen it and they just don't care or are not worried about having inspections done on the property. So including a WDO inspection, I would think that that box is very rarely checked. Your buyers want to do inspections. And either A, B, or C above, buyer reserves the right to do necessary re-inspections. I'm going to catch up on my notes real quick. C, buyer acknowledges that, we went through that. If either A, B, or C above, buyer reserves the right to do necessary re-inspections and or walkthroughs prior to closing or buyer's possession, whichever occurs first, to verify seller has made any required repairs and met the maintenance requirement pursuant to clause 3. So if you have a major repair that has been done, you're gonna want to have that re-inspected right away, because if it wasn't repaired properly, you still want time in the contract period to be able to have that repair redone or fixed. So make sure if there's a major repair, have your home inspector come back out, re-inspect it, make sure it was done right. Don't save that kind of thing for the walkthrough. So you may have a re-inspection and also a walkthrough, and you want to do the walkthrough 24 to 48 hours before closing, because you're going to want to make sure that that house is in good shape and nothing major has happened to it right before you close on the property. You definitely don't want your buyers closing and walking into their house excited only to see a huge major leak that you didn't know about. All right, if buyer fails to do the final walkthrough or notify the seller in writing of any items not repaired or maintained or as required, buyer will accept the property in its current condition. Should sale not close, buyer will repair all damage to the property resulting from inspections and return the property to its pre-inspection condition, with the exception of any damages from the WDO inspection, because sometimes in WDO inspections, those guys will use the end part of a screwdriver and knock on wood. And sometimes if there's wood rot, it'll cause holes and so forth. That's very common. But if you have a home inspector who creates damage by moving siding or accidentally steps through the ceiling when they're up in the attic doing an inspection, then it's going to be the buyer's responsibility to return that property to its pre-inspection condition and at their cost. Clause 12, evidence of title, restrictions, easements. Buyer is advised to have owner's title insurance on all transactions. So the closing will take place in the county where the property is located unless otherwise agreed to in writing by all parties. For example, sometimes if a buyer is buying a house in McCulloch County in Crawfordville, but they may still have the closing up in Leon County, and that's fine. If they've put that title company up there on page 1 and all parties have signed off on that being okay, then that's fine. Closing must be able to be conducted by mail or electronic means, and pursuant to clause 5, that's where it set forth the buyer and seller's responsibilities and costs. The party ordering the title insurance shall order from a Florida licensed title insurance for the delivery to the proposed title insured a title binder to be followed by a title insurance policy upon recording of conveyance. The policies will ensure the title to the real property subject only to liens, encumbrances, exceptions, or qualifications set forth in this contract, and those which shall be discharged at or before closing. If a defect in title is discovered, seller will have 15 days from receipt of notice of said defect with which to clear the defect at seller's expense. So this is important in this clause to know that if the title company flags some kind of title defect, like we were talking about that encroachment of that fence, for example, then the seller has got a 15-day cure period to be able to, at their expense, maybe take down that fence and move it to the proper property line, for example. If any such title defect cannot be cured within that 15 days, the buyer may accept the title and be like, oh, no one's going to complain about the fence, or I can deal with that later. Or the buyer may decide, nope, that's going to be too expensive to cure that defect, and I don't want to move forward in that manner. So the buyer may void the contract and notify the seller using the TBR termination form, and then they're entitled to the refund of their deposit. Title to real property shall be conveyed by warranty deed unless otherwise agreed in writing. One of the things with the title to be careful with too, for example, if sometimes you'll see on the property appraiser's website that it will say that someone's got a life estate and it's for sale under that person having a life estate, but a life estate interest in property is only during that person's lifetime, and they do not have the authority to convey the property necessarily. So that might, for example, be the cause of a title defect if someone who's only got a life estate interest in a property tries to convey that. But anyway, and that can be cured possibly by having the actual person who has the benefit of conveying the land enter into the contract instead. All right. Title to the real property shall be conveyed by warranty deed unless otherwise agreed in writing. There are other kinds of deeds out there, like a quick claim deed, but the standard is the general warranty deed. Seller represents that seller has legal authority and capacity to convey the title of the property with all improvements. Seller shall, and again, that's, for example, a person with a life estate cannot legally represent that they have that authority to make that conveyance. Seller shall furnish to buyer a seller's lien affidavit that there have been no improvements to the subject property for 90 days preceding the closing date for which a lien could be filed. If the property has been repaired within 90 days preceding the closing date, the seller shall deliver seller's lien affidavit indicating payment of all sums owed. So if that seller has improved that property recently and has an outstanding construction lien, for example, that needs to be paid and completed by seller, and they need to sign an affidavit saying that that's been paid for. Okay, if closing company charges work fees, including amount limited to preparation of the deed, municipal lien searches, or lien affidavit, these charges shall be paid for by the party agreeing to pay for the title insurance and clause, and that is a mistake. That should say clause 5. Buyer will take title to the property subject to any assumed mortgages, purchase money, mortgage, taxes for the current subsequent years, special assessments, and those occurring hereafter, zoning and other governmental restrictions, plat restrictions and qualifications, public utility easements, and restricted covenants of record. So your buyer is just needs to understand that when they take title and ownership of the property, there's going to be some strings tied to that, including any taxes that are tied and assessed against that home, and any zoning or other governmental regulations, covenants, and restrictions, just so that they know they're not just buying a house, they get all those other great things. Clause 13, prorations, and I mentioned that we'd talk about this later. So all taxes, assessments, and homeowners association dues shall be prorated for the current year as of the date of closing. So the seller has the prorated amount from January 1st up until the day before closing. And then the date of closing to the end of the year is prorated and assessed to the buyer. Those costs are on the buyer. As to prorations, here we go. The day of closing shall belong to the buyer. If the current year's tax amount is not available at the time of closing, taxes shall be prorated on the basis of the prior year's gross taxes, including applicable exemptions. The proration shall be adjusted at the request of either party when the tax bill for the year becomes available. All prorations shall be adjustments to the cash due at closing. 14, special assessment liens. Special assessment liens as of closing are to be paid by the seller. Pending assessments at closing will be assumed by buyer, provided, however, that where the improvement has been substantially completed as of the contract date, such pending assessment shall be considered a lien, and seller will be charged at closing an amount equal to the last estimate of the improvement by the assessment. So if there's any pending assessment for any kind of improvement the seller has made to the property, the seller is really supposed to pay that off. If there's a minor amount left that can be carried over, the buyer may be responsible for paying that, but really that is to be assessed towards the seller and paid. Any pending assessment lien not disclosed to the buyer, that's another thing. The seller should be disclosing in writing any assessment that's owed. But if the seller doesn't, prior to the final signing of the contract, that will permit the buyer to void that contract and receive a full deposit of the refund, unless, of course, it's paid to by the seller prior to closing. Clause 15. Sometimes a buyer will be buying a property that may be an investment property, or it just currently has a tenant in it and there's still some term length left on the lease. Then this box will be checked, and the seller needs to furnish to the buyer the copies of all written leases or estoppel letters. An estoppel letter sometimes is used commercially to show that the tenant is up to date and current on their payments, and if there's any other kind of information about the lease, the term and duration of the lease. Estoppel letters from any persons without written occupancy agreements within 5 days of the contract date. So that information needs to be handed over within 5 days. Estoppel letters will specify the nature and duration of occupancy and verify all rents and rental deposit monies. If leases or estoppel letters are not received or unacceptable, then the buyer may terminate the contract within 15 days of the contract date and receive their earnest money deposit back and use that TBR termination form. All rental deposits, advance, or prorated rents will be an expense of the seller and transferred to the buyer at closing. So if the tenant, for example, gave the seller, when they initiated the lease, $1,000 deposit, that is going to be transferred to the buyer for the buyer to hold on. And when the lease is terminated, then that total amount may go back to the buyer if the buyer has done everything in the lease they're supposed to, like clean the home and clean the carpet, so forth, and the house is in good condition. Or the buyer may give part of that deposit back or whatnot, depending on the condition of the property. And then if the closing, for example, is in the 15th day of the month and the seller received that whole month's rental payment, then the buyer is going to get 15 days proration worth of that rental money back at closing. Okay, so clause 16, buyer's disclosures. Some of these are some statutory disclosures that are required to be made to the buyer. The following disclosures may contain contingencies. If a contingency has not been satisfied pursuant to the terms of the contract, buyer may terminate the contract within the time frame specified in writing on the TLC TBR termination form and be entitled to a refund deposit upon signing the termination form. If buyer does not report otherwise in writing to the seller within the required time, then that contingency is waived, and the buyer must proceed to the closing and does not get their earnest money back if they walk away. All right, clause 16A, permits. So if buyer acknowledges that some home improvements require a permit from the government entities, and failure to obtain required permits may result in assessments or liens against the property, or may affect buyer's financing or insurance. Buyer is not relying on any statements by realtors regarding permits or previous improvements to the property. There's a couple of things to unpack here. One thing is that make sure your buyers understand if they're buying a house with an enclosed garage, for example, and that enclosed garage does not have a permit that's been pulled and completed on it, then if there is a fire stemming out of that enclosed garage that does not have a permit and it destroys the whole house, the insurance company may come back and say, nope, all the damage, and with the house being gone, you cannot make a claim because that fire stemmed from an unpermitted improvement, and we do not cover that. So just know that your buyers need to be aware of that, because that could later on put them really in dire straits, and you don't want to have your homeowners put in that position. Also, the realtors should not be looking at a really great enclosed garage and say representations like, this must be permitted because it looks like such a great quality job. Just make sure that you're careful about making certain representations about an addition or improvement being permitted. All right, clause B, radon gas. Radon is a naturally occurring radioactive gas that is thought to maybe cause cancer, cancer causing. And when it has accumulated in a building in sufficient quantities, may present health risks to a person who are exposed to it over a period of time. Levels of radon that exceed federal and state guidelines have been found in buildings in Florida, and then they can find additional information from the county health department. So leave that up to your buyers. They can make an informed decision by looking for additional information and reading additional information about radon, but they can decide whether they want to get an inspector to test that. There are also DIY self-radon kits, and I believe the Department of Health for a while at least was giving away free radon kits to have those tests done. But if you have a professional do it during the inspection period, then of course that enables the buyer to be able to negotiate with the seller, maybe to, if they have high radon levels, be able to mitigate that radon. All right, paragraph C, building energy efficiency. We do provide a building energy efficiency rating system information brochure. We have that in .loop, so just make sure that you are sending that to your buyers and that they are reading that. There's also city energy efficiency audits that can be done and different programs to increase the efficiency of homes. So just make sure that you become informed about that and maybe look at the city's website. All right, clause D, property taxes. Buyers should not rely on seller's current property taxes as the amount of property taxes that buyer may be obligated to pay in the year subsequent to purchase. So this is the important part. A change of ownership or property improvements triggers a reassessment of a property that could result in higher property taxes. If you have questions or concerns about valuation, contact the property appraiser's office. So just know that if your homeowner is buying or your buyer rather is buying a house maybe as an investment, and that house previously had a homestead exemption, if that goes away, then when that's reassessed, those property taxes are going to go up. Also, if you have a buyer who is buying new construction and at closing, they're really only paying property taxes on an unimproved lot, well, once they buy that new construction and that land has been improved, then again, those taxes are going to increase a lot more next year. So don't tell them not to rely too heavily on the amount of the taxes that were used for closing. It may change next year and probably go up. Clause E, road and drainage facility maintenance. So this basically just says that it's the buyer's responsibility to know who is responsible and whether it's the government that's retaining their roads that provide access to their property. Sometimes your buyer may be buying a house in a rural area and it is their responsibility or their neighborhood's responsibility to maintain those roads and the roads drainage and maintenance. So just make sure that if that's the case, if your buyer understands and knows that they're buying a house in an area where they're responsible for maintaining it, they need to check there and acknowledge that. Paragraph F, land use disclaimer. Land use regulations are unpredictable and constantly changing. The property is subject to a comprehensive land use plan for the jurisdiction which is located. The use of that property may be affected by restrictive covenants, easements, zoning restrictions, and other land use restrictions. So just make sure that your buyer knows that if their property may be subject to different zoning regulations, and they may not be able to carry a business out in their house if they're intending to run a daycare facility out of their house, and that's a popular example, that there may be either zoning or some other restriction like covenants and restrictions or HOA regulations governing that property, saying that that's not allowed. They need to find that out and do that research and contact the appropriate government agencies to determine if that is allowed. So the contract's not contingent on those. The contract can still close and the purchase can still be made even with those regulations in use. So that is just this disclosure, and that the buyer is accepting all those regulations when they go through with the purchase of the property, and that property is subject to those regulations. So in the seller and realtor, basically the buyer cannot rely on their representations. If a realtor for some reason says, oh yeah, it's fine to carry that business out of your house, well, it's the buyer's responsibility to make sure that that's the case. All right, paragraph G, school zones. This is where the buyer can go to these websites and determine what school zone the house is in, and it's their obligation to be able to do that and determine what schools their children will be eligible for. And then of course you can also, as a realtor, provide them more information about charter schools or any private schools that are in the area, and provide them the Leon County website that explains school choice. Paragraph H, so square footage. As we know, realtors type in usually from the property appraiser's website the amount of square footage that is represented there, but sometimes square footage can be pulled from an appraisal, or there could be third-party companies providing an estimated square footage. Just make sure that your buyer knows not to rely what's provided in the MLS, and if they want, they can get their own measurements done of the property. Paragraph I, sewers versus septic tanks. So it's the buyer's responsibility again to contact the appropriate utility department to determine if the house uses a sewer, a city sewer, and is connected, or if it has a septic tank system. And then the buyer can find out information from the local health department about maintaining that septic tank system and other recommendations as to when a septic tank should be pumped out or replaced, and how to maintain that in the drain field and so forth. All right, paragraph J, inspections. So again, the buyer is strongly advised to obtain inspections, and this clause just really highlights that there's certain defective materials that your buyer should be aware of and make sure are inspected, such as Louisiana Pacific siding. That is a defective siding that I actually have had buyers buy a house that had Louisiana Pacific siding on, appraisal flagged it, and the whole house had to be resided with hardy boards. So just be aware of certain defective siding that should be inspected, synthetic stucco, and polybutylene pipes. Many people are familiar with. These are defective pipes that deteriorate over time and leak, break, and some homes need to be replumbed if that's the case. All right, so just make sure those homes get inspected. Paragraph K, seller's disclosure. And here's where I said I was going to go more in depth with this, because this is really, really important for sellers to understand. Seller represents that seller does not know of any facts that materially affect the value of the property, including but not limited to violations of government laws, rules, regulations, other than those buyer can readily observe or that are known by or have been disclosed to buyer or realtors. And this stems from, let me find the case, Johnson v. Davis. So you may want to write down this site so you can look it up and read it if you haven't already, and you may want to be able to provide this to your sellers so they understand the consequences and their obligation to make certain disclosures when they're selling their home. So this is a landmark Supreme Court case in Florida, And this is where they held that sellers need to make to buyers certain disclosures. And I believe if they don't, they may be subject to treble damages. But I don't know if that's still the case. You want to look into that. But this was the court's holding. Accordingly, we hold that where the seller of a home knows, so of course this only pertains to things that the seller knows about. A home inspection might find a roof leak the seller didn't even know about. But if the seller knows of a roof leak, that's a thing that materially affects the value of the house, they need to disclose it. So accordingly, we hold that where the seller of a home knows of facts that materially affect the value, a scuff mark on the floor or wall does not materially affect the value. So that's not going to count. Materially affects the value of the property, which are not readily observable. So even if it's a big thing and the buyer walks in and they can visibly see that the faucet is dripping or the house is flooding, then the buyer can see that. So again, that doesn't need to be disclosed by the seller if they know it because it's readily observable. That doesn't mean that they should still, in abundance of caution, disclose everything that they know about the house, and are not known to the buyer. The seller is under a duty to disclose them to the buyer. So since I interrupted that, and this is so important, I'm going to read it again. Accordingly, we hold that where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. So I always tell my sellers that in the abundance of caution, they should be disclosing everything that they know about that materially affects the value of that property. That's very important. Okay. Clause 11, restrictive covenants. If membership in a homeowners association is mandatory, they're required to be a part of the HOA, then they have to attach the specific HOA community disclosure, and they need to disclose how much the annual HOA fees are, or if it's charged quarterly, they can state that. I'm trying to remember if I don't have the HOA disclosure form, but it is a one-page disclosure form where your sellers simply disclose how much of any HOA dues that are due, and if there's any other kind of special assessments that they have to pay, maybe for lawn care or so forth, that's disclosed on that sheet. Okay. So buyers should contact that HOA with any questions concerning the property use and restrictions or assessments. Sometimes an HOA will say that you can't park RVs on the property, where you have to have a certain kind of a fence, and the buyer needs to make sure that they read the restrictive covenants and contact the HOA and find out what those restrictions are. Again, it's the responsibility of the buyer to obtain and read any applicable restrictive covenants and to make sure the documents are complete and current. Now, if it's really important to the buyer, like they have a huge RV they have to pack on the property, and so they need to know if it's allowed there, then you might want to make the contract contingent on your buyer obtaining those restrictive covenants, reading through them, and making sure it's okay. And you can make it contingent on them receiving it within 5 days, so they have an opportunity to read it and find them satisfactory. All right. Also, I might mention that you can find those restrictive covenants. Many of the title companies have them online, like North Florida Title Company, where you can just type in the HOA and find out and read them. They're also recorded, so you can look them up and find those recorded documents online as well. Paragraph N, builder's warranty, new construction only. So this only applies if your buyer is building new construction. So here you can check if the builder, seller has already provided the home warranty to the buyer and they've had a chance to read it, they can check there if they accept it. And then if you still need to get that builder's warranty, then you can check that the contract is contingent on receiving that. And the buyer has 3 days after receipt to review and find that acceptable. Or if the builder, for whatever reason, is not providing a warranty, then the buyer can go forward with the contract, knowing that they've been advised there is no warranty on the construction. All right, clause 17, uncontrollable events, risk of loss. This is important for us Floridians because we do experience extreme weather like hurricanes. So under clause A, if extreme weather or other conditions out of control of the parties make the closing impossible, like a hurricane, closing may be extended up to 3 days after restoration of utilities and or other services essential to closing. So that doesn't say 3 days after that extreme weather event occurs. It's 3 days after finally we get any utilities and other things restored so that we can close. So that could give you a good amount of time after even the closing date. But if the closing cannot happen within 14 days after the closing date, either party may terminate the contract by delivering written notice to the other party, and the buyer will be entitled to receive a refund of the deposit, releasing the buyer and seller from all obligations under the contract. Sometimes the damages are just so bad from an extreme weather event that the closing won't be able to happen anytime soon because of repairs that are needed. All right, clause 17B, the risk of loss or damage to the property is assumed by the seller until closing. So if a tree falls through the house before the day of closing, then the seller is responsible for taking care of that and remedying it. If it happens on the day of closing, then that risk of loss is passed on to the buyer, and that's now the buyer's problem. If property is damaged in excess of 3% of the purchase price, buyer will have the option to avoid the contract and walk away and receive their refund of their deposit. But if the property is damaged up to and including 3% of the purchase price, then the seller gets a cure period. The seller has 15 days then to restore the property to the original condition as of the contract date and still proceed to the closing. If the 15-day period extends past the closing date, then the closing may be extended up to 15 days past. If the 15-day period extends past the closing day, the closing may be extended up to 15 days past the closing date. Seller will notify buyer in writing if the property cannot be restored within those 15 days. Buyer then can void the contract and notify the seller with the TBR termination form and get their money back. All right, clause 18, failure of performance. Clause A, so if a buyer fails to perform the contract within the time specified, including for payment of all deposits, the deposit paid by the buyer may be retained for the account of the seller as agreed upon liquidated damages, consideration for the signing of this contract, and in full settlement of any claim. So basically, if the buyer breaches the contract, and doesn't meet any of the time limitations specified in the contract, then their earnest money deposit is given up as settlement for that breach of contract. However, that might not satisfy the seller, for example, and so the seller has another option. So the seller may, at seller's option, proceed to enforce the seller's rights by seeking specific performance. So if that earnest money deposit is not going to satisfy the seller and the buyer has truly breached the contract, then the seller may go to court and require the court to make the buyer purchase the property and close on the property. Clause B. This is the other side of the coin. If for any reason other than failure of seller to make seller's title marketable after diligent effort, seller fails, neglects, or refuses to perform the contract, the buyer may seek specific performance or elect to receive the return of buyer's deposits. But that is without waiving any action for damages resulting from the seller's breach. So the buyer can either, if the seller breaches the contract, the buyer can either ask for the earnest money deposit back, or the buyer can seek specific performance and have the court order the seller to sell that property to the buyer and close on it. And if the buyer goes that route, that does not waive the buyer's ability to still sue for any damages related to them not being able to timely close on the property and the seller breaching the contract. Clause 19, attorney's fees and costs. Okay, so in connection with any litigation, including appeals arising out of the contract, the prevailing party shall be entitled to recover all costs incurred, including reasonable attorney's fees. So whatever side loses when there's a litigation battle, then that losing side can be on the hook to pay for both the prevailing side's attorney's fees and costs and their own attorney's fees and costs, and that could be substantial. So that's a really hefty decision if you decide to sue somebody in a real estate deal. Also, sometimes the escrow agent is involved. That may be the title company that's holding the earnest money deposit or any other funds related to the transaction in escrow. That escrow agent may, at agent's option, continue to hold the escrow money, or they may not want to deal with it, and they may want the clerk of the circuit court having jurisdiction over the dispute to take that money and put it in their own escrow account. However, if the escrow agent interpleads, that means they want to become a part of the litigation and a party to the litigation, then and it's about the subject matter of the escrow, then the escrow agent can pay for their filing fees and costs out of that escrow account, out of that money in that escrow, and they in fact can recover reasonable attorney's fees and costs that can be paid from the escrow funds. All right. Clause 20, addendums. So these are certain addendums that may be attached to the contract, and if they do, then they become part and parcel of the contract. So again, which upon signed by both parties are made a part of the contract. So condominium riders, if your buyer is purchasing a condominium, and if you are a new agent, you may want to get the support and help of a more experienced agent who has sold condominiums, because with condominiums, there are many different things associated with them than a normal real estate transaction. For example, your buyer may have to apply to the condominium just to even become a member and own that property, and they may be subject to paying condominium fees for common elements in that property. The condominium may cover different things that wouldn't typically be covered in home ownership, like a termite bond, pest control, maybe internet services. Anyway, condominiums are a little bit of a different animal. In fact, lenders, not all lenders provide loans for condominiums, so sometimes it's hard to even track down a lender who will provide a loan for a condominium. All right. FHA, VA, a mandatory clause, and real estate certification. So for FHA and VA loans, the lenders are going to want a separate addendum that is going to restate that appraisal clause again, saying that that buyer is not on the hook to buy the home if there are any issues with the appraisal coming in low in value. HOA community disclosure, that's that form I was talking about, that one-page form that says how much the HOA dues are for a community, and if there's any other kind of special HOA assessment for lawn care or events or anything like that. Insulation rider, so this is for new construction. So whenever there's new construction, a builder has to disclose the insulation, what type. I'm trying to catch up on my notes. The thickness of the insulation, the R value, which really measures like the how well the insulation can resist heat. They have to disclose all that in the insulation rider. And then lead-based paint disclosure is a form where the sellers have to disclose if they know about any lead-based paint, if they have a house that was built prior to 1978. Again, if it was built in 1978, they're safe. They don't need to fill out that lead-based paint disclosure. But if it was built prior to 1978, then they need to fill out, the seller needs to disclose if they are aware of any lead-based paint, if there's been any repairs or mitigation for lead-based paint. And then the buyers have to sign off that as to acknowledging what the sellers have disclosed, and they have to be given the opportunity to be able to inspect for any lead-based paint. The TBR Realtor Short Sale Addendum. So this is a separate addendum that needs to be filled out if the buyer is purchasing a short sale. And again, this is one of the situations, if you're a new agent, you may want to get with a more experienced agent who can kind of explain the short sale process, and know that you are going to be working with a lender, the seller's lender, and maybe some of the terms and conditions that are tied to having a short sale. TBR Realtor Special Clause Addendum. This special clause addendum might be checked and included in the contract for several reasons. It kind of covers a whole gamut of things. Here's that special clause addendum. You put the seller, the buyer, the property at issue. And then I will probably do a video more in depth of this addendum and things like the counteroffer But just to give you a quick overview, if your buyer can't get their pre-qualification because the offer is made over the weekend or something, then you may want to offer to get that pre-qualification to the seller and represent that you'll have that to them within a certain amount of days. If the seller is financing the property, because that's a different animal and that's heavily regulated, you're going to want to check this and make sure that your buyer is providing information to the seller that is going to allow them to be approved to be able to be financed by the seller, like their credit check. And if the buyer is buying a property and they have to sell their own property to be eligible to get a loan to buy that property, then they would mark that contingency here and say that they will try and have it under contract and close on a certain day and represent that to the seller. The seller may say, well, I don't like that kind of contingency, so I want to still be able to advertise and market my property. And then they would check this first right of refusal if there's this kind of contingency, and then they can still advertise. If another offer comes through, then they can say, well, we want to take this new offer. Here, buyer, you need to remove this contingency in 48 hours, or we're going to go with this other buyer. And if they're unable to remove that contingency, then they can go with this other offer. That's the first right of refusal. And I am oversimplifying it, but I will explain that more in depth in another video at a later date. So this is a contingency if the buyer already has their house under contract and it's already got a closing date, then it's much more simple and much more of a head start than those. So you would simply check that your house is under contract, it's going to be sold and closed on a certain date, and then we can close on under this contract. So a backup contract, if a house is really, really enticing to a lot of buyers and they don't care that it's under contract and they want to submit a backup offer in case the first one falls through, then this is the way that they would go about that. And then land and property use. So if there is a lot of land that is being sold and they want to have the buyer wants to have some soil tests or other tests conducted, then you would put this on here and make it a condition of the sale and verify that give them time to verify that their own and other government laws that are in conflict with the purpose of buying that property. And then you can check this if the purchase is a tax deferred exchange, which means that really the buyer most likely is an investor who is taking one investment property and they want to use that and sell that and take those proceeds and buy a different investment property that may be more, or it might be the same type of property, but it's a better investment situation to have the money tied up there, or they may take money from their one investment and tie it into use that money to tie it into multiple properties. And the 1031 exchange is really called a like-kind exchange. It's really meant to be kind of like a house swap, like giving up one house for a like-kind, similar type house. And the whole point of that is when you do that, the government is letting that seller / buyer avoid capital gains. So investors like it because if they're going to just take the money from one property and put it into another property, that's one way that they can avoid having capital gains tax on that house that they are selling. But there's a bunch of strings attached to that, like they have to be able to make that sale and purchase within a certain timeline and so forth. So again, if you're doing this kind of sale, then you may want to get with a more experienced agent who can kind of walk you through what that looks like and what needs to be done. If you have any other kind of terms, usually that's worked out in the actual offer in clause 21 and under special clauses, but you can signify something else here. And then this one is really important for us realtors because under clause 10, if you are a real estate agent and you have an interest, an ownership interest or financial interest in the house that you are selling, you have to disclose that to the buyer. So you would be disclosing that there. And of course, that's where the parties all sign off on it, make it part of the contract. Special clauses, again, this is just a general spot that you can negotiate any other terms into the contract. Like you specifically want to install a new roof and you want to set aside and put that they're responsible 50-50, the buyer's paying 50%, seller's paying 50%, or whatever other kind of special terms that you want set aside here, you would put there. One word of caution, agents should be careful that when they are drafting this and they start getting into drafting legal terms, that they may be committing unauthorized practice of law. So it may be a good idea to run this by an attorney, have the buyer run it by an attorney. Maybe you choose to have your closing at a title company that is a law office, and they can look through that language and kind of put their stamp of approval on it when you draft it. Just be careful there that you're not practicing unauthorized practice of law. All right, clause 22, notifications. So upon the signature of all parties, the contract constitutes the entire agreement. So in legal wording, I guess, the entire agreement means the four corners of the agreement. So anything that is written within the four corners of this document and are signed off on and dated becomes a part of the agreement. And what this really is getting at is that if there are any verbal agreements that are outside the four corners of this document, those do not count. Neither party is obligated to follow through on any verbal agreements. It's only what is written herein and signed off on. Electronic signatures will be acceptable and binding. Written provisions inserted in this contract and amended and attached addendums will control all printed provisions in conflict. So just know that whatever is drafted by addendum later in time, if it conflicts with the original provisions that are in this contract, it will override these. So whenever you're drafting an addendum, if you don't intend to conflict with anything in the original contract, make sure you go back and read the original contract and make sure that you're not negating something that was in the original contract. The placement of an extra check within a box shall make the provision applicable. All notices will be in writing and will be delivered to the parties, realtors by mail, personal delivery, or electronic media. This bolded sentence is really important. Any notice, document, or item delivered to or received by an attorney or licensee, including a transaction broker, representing a party, will be as effective as if delivered to or received by that party. So whenever a real estate agent receives and has delivered to them something, it is deemed that whoever they are representing, their buyer or their seller, has received it as well. So for example, if the buyer makes an offer and then their counter offer is going back and forth and the buyer submitted a counter offer to the seller and the seller says, fine, we've signed off on it, you know, we're ready to go under contract. So the listing agent sends that counteroffer signed and executed to the realtor, and then the buyer's agent has received that, but they haven't given it to their buyers yet. And the buyer's agent confirms receipt with the listing agent. And then right when the listing agent receives that confirmed receipt, they get a cash buyer for full price on their seller's property. And if the listing agent tries to say to the buyer's agent, have you given that document to your buyers yet, the executed counteroffer? And if the buyer's agent says no, then the listing agent, who may say, well, then we're rescinding that agreement, we're not under contract. The buyer's agent is going to say, no, it's constituted delivery, I've received it, we are currently under contract, and that's the case. So just be careful when something is delivered to that other agent, it's as if it's delivered to that seller or as if it's delivered to that buyer. You can't take anything back at that point. All right, clause 23, time for response, contract date. So this is where you need to put the response time and deadline for the seller to be able to accept or counter this offer. So if contract for sale and purchase is not executed by seller and buyer, or a counteroffer submitted prior to, put the date and the time, the deposit will be returned to the buyer and this offer will be null and void. And so at the very first top part of this contract, we put that the deposit's not going to be submitted for 3 days. So you won't really have a deposit returned because that's not turned in until after you go under contract. But there is some strategy involved in when you would put your response timeline. Of course, if it is a new listing and there's lots of attention and multiple offers, you're not going to want to give them 3 days to respond. You're going to want to have that turnaround time pretty quick. But you also don't want to make it an hour where you're just going to make the seller mad and they're not even going to want to work with you. So just be aware of what is a reasonable timeline, turnaround timeline, and work that out with your buyers. Okay, again here, and I've mentioned this several times, the contract date will be the date when the last party dated and signed the offer or final counter offer. Okay, so clause 24, time is of the essence in this agreement. I went over this at the very beginning, but all references to time frames shall be calendar days, including weekends and holidays, and in the time zone where the property is located. So just be aware of when you are making these timelines or setting a closing date that the timelines calculated include weekends and holidays. There's no exceptions for those. So include those when you count out days. And then also the time zone where the property is located is what is used. So you may have an out-of-state seller who's moved and they're trying to sell their house from afar, and he may be thinking in his time zone or her time zone, and really it's where the property is located. So keep that timeline in mind. And also, you know, if there's a property that's being sold closer to Panama City where the timeline change is different, that might be more important as well in areas like that. All right, and then clause 25, this legally binding contract. If you not fully understand it, seek the advice of a real estate attorney prior to signing. Make sure you explain that that might be a good idea in some of these complex cases for them to seek that advice of that attorney. Like I mentioned, when there's a bunch of special clause provisions drafted in clause 21, you might want that looked at. This contract shall not be recorded. So it's not an official recorded document. This is just between the two parties, the buyer and seller. All right, this is where the buyer would sign off on the offer they're making. And this is where the seller has options to either accept the offer, check there, or the seller can counter the offer. And if the seller counters the offer, then they are going to use this form. And here they would put on their first one, counter offer 1, they would put the parties in again, they would put the date of the initial offer. Sometimes the counter offer is made the second day after the offer comes in, for example, the address at issue. They can put in the, and just know this, when you make the counter offer, and it is only changing the terms of the original offer. So say no one signs off on this counter offer, and then there's another counter offer that the seller's counter off back with. That does not impact this counter offer. Anytime you write a counter offer, it only applies to the language that was made in the initial offer. It does not, one counter offer does not impact the language of another counter offer. So anytime you do a counter offer, you're starting as a new, like, and against the original offer. Okay, so you may change the purchase price. And when you change the purchase price, it says all financing figures are adjusted accordingly. So you don't need to change the purchase price here and then go down here and put, scroll back up. You don't need to go back and then start changing the amount of the new third-party financing and then change the amount of the balance of a down payment that's supposed to be changed. All those things are automatically going to change when you change the purchase price. So you don't need to waste space and work on that as well down there. Just change the purchase price. And then you can change the closing date, and then you can say that additional items are included. Like you may have forgotten that extra washer and dryer in the carriage house, and that needs to be included in there, or you forgot to look at the seller's property disclosure and exclude certain things from the purchase, or that's negotiated. The sellers want to keep that hot tub after all because they're not getting the price they want, so exclude that there. So make sure that when you draft the clause and line number, I see this all different kinds of ways. And when you read a contract, this is I'll give you an example here. This is the section in the subsection. So it's 4A is how you would cite this line. And then you cite the line numbers 22 and 23. So if we were modifying that earnest money deposit there, then you would do 4A and the lines 22 and 23. And that's what this looks like. So you would do, let's see if it's going to let me write. Might need to do this. 4A and then lines 22 through 23. Or if you're just changing line 22, you would do that. And that would go more there. And then you would write in the term like change amount of deposit to $3,000. You would write that there. Anyway, all right. Okay. So going back down to the end of the contract. And then the other thing that the seller can do, of course, is they can reject the offer, or they can just let the time lapse and not respond within that time. And then they are rejecting the offer. And then the final steps are to put in the buyer's agent information, their company name, the company license, real estate number, email, and phone number, and then the listing agent's information, contact information, and licensure number. And there are a lot of agents who do not take the time to kind of fill this out, and it's really easy. I mean, sometimes they don't look up the company license number or their own real estate license number. But this stuff is important to find out or to put on here because it's a reference point for both agents and the buyer and seller. So take the time to do it. All you got to do to find the company license and agent real estate number is to go to the Florida DBPR website. You hit search for a licensee, and then you do search by name. And then, for example, you can put in, your name, and then sometimes it helps if it's like John Smith, a common name, to put the city it's in, narrow it down, search. Oh, you know what? I forgot they don't have my apostrophe, I think. I don't know why I did that. Maybe they do. Let's try that. I'm gonna have to do it old school. Type it in. All right. So then when my name comes up or any agent's name comes up, you come up and copy that, and then you would plug that in under the agent's real estate license number. And then you'll want, and I mean, you can do this for the other agent on the other side too, to make sure that the contract is completely filled out. And then when you're looking for the company's name, again, you search by name, but then instead of typing in the person's name, you're going to type in the organization's name. And in this case, put Keller Williams. I'll just leave town because that's enough if you also include the city. And then hit search, and then looky here. So Big Bend Realty Team, we're doing business as Keller Williams, but this is actually our corporate number. So you would put that in there as your company license number. Do the same thing for the agent on the other side, fill out that information, and then you are ready to submit your offer. So I hope that you found that very helpful. And again, if you have any questions on this, feel free to call me 850-339-7639. I hope you enjoyed the presentation, and I hope you have a great day. Thanks.